This presentation will give you everything you need to successfully pass your interview, advocacy, and drafting exams. Property Law, Part 2 and 3 of Deducing Seller, Investigation Buyer, and Reporting on Title. Deducing title done by seller's solicitor, who collates all the title documents, reads through them to ensure the seller owns the property, and is entitled to sell it, and sends them to the buyer's solicitor. SCS 4.2.1 and SCPC 6.2.1. In registered land, the following documents constitute deducing title: official copies of the register, title plan, copies of documents referred to in the register that have not been copied out in full on the register. Protocol and Standard Conditions 4.1.2 require seller to provide official copy entries of the register and copy documents incorporated or referred to therein, so far as not overridden or discharged at completion. Investigating title done by buyer's solicitor, who reads through all the title documents to ensure the buyer will obtain good and marketable title. In registered land, the aims of the buyer are to identify the extent of the property and the rights that benefit it. Identify the class of title, e.g. absolute, qualified, etc. Lenders insist on title absolute. Ensure that the seller has the right to sell the property. Identify the extent of other people's rights over the property. The register comprises 3 separate registers. A property register describes property including the county and district where it is situated, the date the property was first registered. It identifies the legal estate as leasehold or freehold, refers to a title plan and address. This register also identifies the rights benefiting the property, such as rights of way, etc. These will have been fully extracted, annexed to the register, or referred to by reference to a dated conveyance. B. Proprietorship register gives class of title, owner's name, and entries affecting owner's rights of disposal. It enables the buyer to check that the seller has the right to sell the property. C. Charges register lists charges affecting property and third-party rights over the property. And B. Schedule late indemnity. If the land registry has made a mistake in registering a title with title absolute, and a party with an interest in the land suffers loss as a result of an error or omission in such registration, the land registry will indemnify them for their loss. The registered proprietor, as listed in the proprietorship register, is usually the only person who can sell the property. This may be either an individual or a company. They may own the property as either tenants in common or as joint tenants. In more complex transactions, the vendor could be a personal representative of the registered proprietor, an attorney acting under a power of attorney, a mortgagee exercising a power of sale. B. Proprietorship register. If the seller is registered proprietor and an individual, they must sign both the contract and the transfer. If the seller is registered proprietor and a company, the buyer must check that the company has been registered and still exists, is not subject to any fixed/floating charges, and is not being wound up. If the sellers are registered proprietor and tenants in common, there will be 2 names listed in the proprietorship register, and the land registry will have placed a restriction on the B. Proprietorship register. If both ticks are alive, they must both sign the transfer and contract. If only one is still alive, the other tick's interest must be overridden by appointing a trustee. The second trustee is effectively acting as trustee on behalf of the interest of the deceased's equitable interest in the property. It will be necessary to see an official copy of the death certificate and the deed appointing the trustee. If the sellers are registered proprietor and joint tenants, there will be 2 names listed in the proprietorship register, but the land registry will not have placed a restriction on the B. Proprietorship register. If both JTs are alive, they must both sign the transfer and contract. If only one is still alive, it will be necessary to see an official copy of the death certificate and the grant of representation/probate, where the seller is not the registered proprietor, usually because they have died. If the sellers are personal representatives, PRs, and B, all the PRs must execute the contract and transfer. In order to get good title, the buyer must see an official copy of the register and an official copy of the grant of representation. It is also good practice to ask for the death certificate. If the PRs are transferring title to a beneficiary under a will, the assent must be in writing, signed by all PRs, and name the beneficiary to whom the property is being assigned. S36(7) Administration of Estates Act 1925. If the sellers are acting under a power of attorney, it is necessary to also check that the power is granted by the D.11 Powers of Attorney Act 1971, that the attorney is acting within the ambit of his power, and that power has not been revoked. NB Personal bankruptcy revokes a power of attorney. The maximum period that a buyer may assume a power of attorney is valid for is 12 months. S54 Powers of Attorney Act 1971. If completion is more than or exactly 12 months after the power was granted, the buyer must make a statutory declaration that they aren't aware of a revocation of the power, and b. that the donor gives the power of attorney, therefore the attorney is the donee. If the sellers are lenders exercising their power of sale, the buyer's solicitors must check that the power of sale exists by virtue of there being a mortgage on the property, and that it has arisen by virtue of a breach of contract. The seller's solicitors must also check that the power of sale is exercisable by virtue of unpaid interest for 2 months. S103 LPA 1925. S105 LPA 1925 deals with the distribution of funds pursuant to a sale by lenders exercising their power of sale. See Charges Register. Identify the extent of other people's rights over the property. A buyer will be bound by some third-party rights over freehold land. as 29(2) LRA 2002. Interests registered on the Charges Register and interests over writing register. Disposition Schedule 3 LRA 2002. The most common charges found on the Charges Register are mortgages, property pledged as security for a loan. Mortgages are protected by 2 entries in the Charges Register. Restrictive covenants restricting the covenanter from e.g. using the property as business premises. Restrictive covenants are either fully set out in the register or by reference to a document annexed to the register. Positive covenants requiring the covenanter to do something, e.g. maintain a fence. Positive covenants do not run with the land and are therefore only enforceable against the original covenanter. For this reason, the vendor will require the purchaser for an indemnity covenant that will have the effect of indemnifying the vendor for any loss he suffers should he be sued personally for breach of a covenant. A note of the indemnity covenant appears on the B Proprietorship Register. The most common interests over writing register. Disposition Schedule 3 LRA 2002 are leasehold estates granted for 7 years or less. Interests of persons in actual occupation. Legal easements and profit to rent. These must have been either obvious on reasonable inspection of the land or used within a year of transfer to be binding. NB Professional Conduct Rule 2. Solicitors must keep their client informed. Official copies must not be more than 12 months old. The Land Registration Act 2002 came into force on the 13th of October, 2003. Its key aim is to allow dispositions of land to be dealt with electronically. It has also increased the number of registrable interests. Specifically, grants/assignments of leases with 7 years or longer to run are now registrable, and all reversionary leases must be registered. Rent charges, franchises, and profit to rent are also registrable. A reversionary lease is a lease granted to give possession to a tenant in the future more than 3 months from today. These are also registrable. In addition, certain notices, restrictions, and cautions may be entered on the register. Notices protect encumbrances, such as a Matrimonial Right of Occupation Family Law Act intended to bind third parties. Restrictions prevent dispositions of the estate from being conducted that do not comply with the terms of the restriction. Cautions only deal with unregistered land. They act as a caution to any intended purchaser of e.g. an easement over the land. The full list is set out at S27(2) LRA 2002. This section also states that if you fail to register a registerable disposition, the seller will hold the property on their trust for the buyer until it is registered. Overriding interests. Sections 11 and 12 and Schedule 3 Para 3 of the LRA have reduced the number of overriding interests. Interests should only have overriding status where it is not reasonable to expect nor sensible to require registration. The burden has shifted so that the person with the right over another's land should protect that right by registration. In practice, this means that if the buyer carries out a reasonable inspection of the land, his solicitor carries out the relevant searches, and receives honest answers to the relevant questions, that buyer should purchase a property free from overriding interests. Many categories of overriding interests are being phased out over the next 10 years, and will require registration to be enforceable. These include right to payment in lieu of a tithe, and the liability to repair a church chancel. S-117 LRA 2002 note interests of a person in actual occupation are overriding unless their occupation was not reasonably obvious to the buyer, and the buyer did not have actual notice of their interest. Assuming that a buyer carries out an inspection of the property, and it is not reasonably obvious that there is a third party in actual occupation, if the buyer asks the vendor about persons in actual occupation, and the vendor does not disclose when reasonable to do so that there is a third party in actual occupation, he may be abroad for a period, the buyer takes the property free of any interest owned by the third party in actual occupation. Similar rules apply to easements. A legal easement is an unregistered interest overriding a registered disposition, i.e. binding unless it was not reasonably obvious to the buyer. The buyer did not have actual notice of the easement, and the easement has not been used within the year before completion. Legal easements can be created in 4 ways expressly by deed. Since Act 03, this must be registered as 272D LRA 2002. Acquired by prescription. Created by implied grant pursuant to S62 LPA 1925. Elevated from license by transfer, under the rule in Weldon v. Burroughs. Entries must be made in the registered title of the servient and the dominant land. Squatter's Right Schedule 6 LRA 2002. If a squatter has been in possession for an unbroken period of 10 years, he can apply to become the registered proprietor. Schedule 6-11 LRA 2002. He cannot make a valid application if there are adverse proceedings against him. Upon receipt of the application, the registrar must serve notice on all those who would be prejudiced by a successful application. If a counter notice is served, the registrar must reject the squatter's application, unless it would be unconscionable to do so. The squatter is otherwise entitled to the land. The disputed possession is a boundary dispute with a neighbor. 2 years later, if the squatter makes a further application and no successful steps have been taken to evict him, the registrar must register the applicant as proprietor in place of the existing proprietor. Schedule 6 Par 7. If the transaction at undervalue was made by a company, similar to a trustee in bankruptcy for an individual, the company's liquidator has the right to apply to set aside any transactions at undervalue made by a donor company to a connected person which took place within the relevant time. S.238 IA 1986. This applies unless the transaction was undertaken in good faith for the purposes of carrying on a business, and at the time of the transaction there were reasonable grounds for believing it would benefit the company,